All right, this is the Tessa Clarine Trotter Mowell versus Zachary Lee Mowell, and it is for final hearing on the divorce action that's been filed in this case. And Mr. Mowell, you're representing yourself pro se. There's no, I don't believe there's an answer that's been filed.
There has not been an answer filed, Judge.
Right. So,
Due to the fact that he is in jail, we did not file a default, but it will be similar to a default as we present.
our appellate courts have ruled that even though you're incarcerated, you have the right to have participation in this action, but because you have not filed an answer, you will be limited to observing what takes place at this point in time. Right. Ms. Duke, you wish to put on your proof if you want to bring, are there any other witnesses?
There are no other witnesses. It's Ms. Mel today.
Can we bring Ms. Mel for her testimony up since she's in a wheelchair to the
Absolutely.
witness block? You'll come around, Ms. Mel, we're going to ask you to.
If you would, please state your full name for the record.
It's Tessa Clarine Mowell.
Ms. Mal, you are currently married to whom?
Zachary Mowell.
Okay. And Mr. Mal is currently incarcerated, is that correct?
Yes.
Okay. And is he incarcerated due to the, and you just say yes, on July the 1st of 2024, he attacked you, is that correct?
Yes.
And as a result of that attack, you almost died, is that correct?
Yes.
You have been rehabilitated, is that correct?
Yes.
Okay. And is this in fact Mr. Mal here on the video screen?
Yes.
Okay, and he is in fact the one who attacked you, is that correct?
Yeah.
Due to the attack, are you, have you incurred significant medical bills?
Yes.
Okay, significant time away from work?
Yes.
Okay, significant time away from your sweet boys?
Yes.
Okay. And have you had to go through very painful physical therapy?
Yes.
Okay. You had 9 stab wounds, is that correct?
Yes.
Okay. And when they transported you, they had to transport you on your stomach, is that correct?
Yes.
Because of a knife that was in your back.
Yes.
Since that time, have you, were you also set on fire on that date?
Yes. I was.
Okay. But you survived those injuries.
Yes.
And are you asking the court to consider the things that we've just gone over in awarding you the assets in the marital estate?
Yes.
Okay. And the only assets in your marital estate due to the fire at the residence are the residence itself, which is in a dilapidated state right now, is that correct?
Yes.
And 2 vehicles, which the court has already given you permission to sell, is that correct?
Yes.
Okay, the truck and your vehicle. You've retitled those vehicles at this point in time, is that correct?
Yes.
And your vehicle, the car, has got a lien on it still, is that correct?
It is.
Okay.
Yes.
And you're working to get that paid off?
Yeah.
Okay. The home has still got a mortgage on it, is that correct?
Yes.
In a perfect condition, how much would you tell this court that that house is worth?
About 300.
Okay. And your home, did homeowners deny your homeowner's insurance as a result of the fact that that your husband set fire to the home?
Yes.
Okay. Are you asking this court to take that into consideration when he's awarding the marital estate, when he's dividing the marital estate?
I'm sorry, did you say the insurance company has denied the claim for insurance because it was an intentional fire by?
Because it was arson. Yes, sir.
What company was that? What was your insurance company?
I believe it was State, Allstate or State Farm?
I want to say State Farm.
Doesn't really matter, I was just curious.
I believe it was State Farm, Judge. And at this point in time, the house in the condition that it's in, is it worth probably less than what's owed on it?
Is it worth less?
Is it worth less than $180,000 because of the fire that was set on the inside of it?
I want to say that.
Okay. And do you know about how much in damage, how much it's going to cost to repair that home?
About 50 to 70,000.
And after that, there probably will be $25,000 to about $30,000 in equity. Is that correct? Okay. Based on the fact that Mr. Mal is in jail and looking to be sent to prison after a subsequent criminal trial, are you asking this court to award you all the equity in the marital residence and all of the value for the vehicles as your child support and any spousal support that he may be required to pay?
Yes.
Okay. Prior to him going to jail, was he earning approximately $60,000 at Dial Tile?
He was.
Okay. And you say approximately because that is he was never very forthcoming with what he was making. Is that correct?
Yes.
Okay. And you believe you would be entitled to more than just the equitable portion of the estate for child support purposes, but you're asking the court to award you the house at this point and the vehicles. Is that correct?
Yes.
At this point in time, do you know, was Mr. Mal honest with you about anything he was doing with retirement? Do you know if he has retirement?
I just knew he just started late.
Okay. And are you waiving your interest in any retirement at this point? To his retirement? He had like $300 in it, is that
Yeah.
correct? Okay. Are you asking that the court allow you to keep your retirement?
Yes.
Okay. Is there anything significant in your retirement at this point in time? Okay. Now, there was a GoFundMe and some other some other monies that you collected due to your injuries. Are you asking the court to award those to you
Yes.
as having occurred after the fact and they were raised specifically for you, gifts to you? Okay, they are separate property. They are not his property. Is that correct?
Yes.
Now, on to the very most important thing in this trial today are your children. Are you asking that this court awards you sole custody of your minor children?
Yes.
Okay, and that is Jackson and Carter Mal, is that correct?
Yes.
Okay, and are you asking that this court maintain there is a order of protection in place based on the injuries that you incurred? Are you asking this court to put down a permanent injunction preventing Mr. Mal from having any contact with you or your children?
Yes.
Okay. Are you asking that pursuant to the parenting plan that you be awarded all holidays, all visitation, all the tax deduction, that if Mr. Mal were to get out, are you asking that Mr. Mal be required to carry a life insurance policy on himself for the benefit of your minor children?
Yes.
Okay. Are you asking this court to make sure that if Mr. Mal does get out, that Mr. Mal start paying child support for these minor children?
Yes.
Okay. Is there anything else you'd like to ask this court to award you as far as the children are concerned? Are you asking the court to prepare a separate order regarding what else we spoke about?
Their last names.
Okay. Are you asking that their last names be changed?
Yes.
Okay. Are we living in a very small community where that Mr. Mal's name is identified as being criminal in nature, and you're asking that your children be absolved of that?
Yes.
Okay. And you're asking that your children be named to your maiden name, is that correct?
Yes.
And are you asking that your maiden name be restored at this point in time?
Yes.
Okay. And for purposes of anonymity, we're not going to say your maiden name out loud, but the court's got it in their file. Okay. Are you asking that these minor children also drop their they've got 4 names, is that correct? 2 middle names for both of them?
Just the first one got the 2.
Okay. Are you asking that they drop the name Lee that is synonymous with Mr. Mal?
Yes.
Okay. Judge, that is our proof.
All right. Ms. Mal, my understanding is that because of the assault on you by Mr. Mal, that you sustained 9 stab wounds and that you were then, he set you on fire as a part of this attempt on your life. And I see that you're in a wheelchair today. Are you confined to a wheelchair, or are you able to get around?
I'm confined. I can walk just a little, but it's everything I have.
Okay. All right. Well, it is unfortunate that we're having to have this hearing at all, but I will hear from any other witnesses. Do you have any corroborating witnesses?
I do. I have one back here.
Let's just let Ms. Mallow stay where she is, and then we'll bring up the corroborating witness.
Well, and if you need to, Judge, I've got Ms. Roberts. She can corroborate also if you need an extra one. But I'd
So
love
we're
to
going
put
to
her
place
under-
Ms. Roberts
I'd
under
love to
oath
put her
as
under
well.
oath.
I'm limited to the testimony.
Well,
Just
now
so
I
that
think
there's not an issue.
I will be the judge of how limited we're going to be with questions. All right, both of you raise your right hand. Let's place you under oath. All right, Ms. Duke.
Ms. Roberts, did you hear everything that was said and everything that was testified to? And so you know everything that Ms. Mal has said today to be true and correct to the best of your knowledge? And you think that it's in the best interest of the minor children to have no contact with their father and for Ms. Mal to be awarded the marital estate?
It's a mess.
If you would, please state your full name for the record.
Timothy Wade Trotter.
And Mr. Trotter, you heard all the testimony today, is that correct?
Yes.
And is it true and correct to the best of your knowledge, everything that's been testified to today?
Absolutely.
It's in the best interest of these minor children to never have contact with Ms. Mal again. Everything else that Ms. Mal testified to, she's entitled to the marital estate, and you've observed the condition of the marital residence and of the vehicles. Its arrest, and currently there's still all devalued to some degree. The division of the marital estate is equitable, having been awarded to Ms. Mal. Judge, that's our proof.
All right, Ms. Mallow, you can come back if you'd like. The court finds, based upon the proof in this court, that the wife is, or that the plaintiff wife is entitled to a divorce on the grounds of an attempt made by the husband on her life by means of malice, including the stabbing and setting her on fire. And that's a ground set forth in TCA 364107, subsection 7. It obviously constitutes the inappropriate marital conduct, but I think that prior finding is more appropriate. The real property that's located here has de minimis value at the present time because of the fact that it's in a state of disrepair. It's going to require expenditure of monies before it will actually be marketable in any event. The law requires that the court, in considering a division of marital property, to make that division fairly or equitably without regard to fault. And so I am stating on the record that I am making this division of what I consider to be a fair division without regard to the fault of Mr. Mowell and his attempt on the life of his wife. But because of that attempt on her life and the injuries that she has sustained and the damage to the real property that has been occasioned by Mr. Mowell's actions, according to the proof in this case, the equitable distribution of property is, in my opinion, favors the wife. And for that reason, I will award her all of the equity that may exist, if there is any, in this real property. She's awarded the title to the property, free and clear of any claims of the husband. Of course, that is subject to the mortgage interest. And I also would point out that part of my consideration has also been the fact that his actions, as proven by the proof in this case, led to the denial of insurance coverage on the damage to the property. Go ahead. And the two vehicles that were involved in the case represent the only other assets that the parties had. And for that reason, because of the medical expenses that Mrs. Mowell has incurred. It is my opinion that all of those assets should be awarded to her to help to compensate for the medical expenses and so forth, and the damage to the real property that were occasioned by Mr. Mowell's conduct.
But we're also asking for attorney's fees. At this point in time, I can submit an affidavit.
Submit your affidavit, but I believe she would be entitled to attorney's fees as well. He will be awarded the retirement account in his name only. She will be awarded the retirement account in her name only. Any monies that were acquired by the GoFundMe account that was set up following this event that led to her injury and hospitalization will be awarded to her as her separate property. Is there any other asset or property that I have not dealt with?
There isn't, Judge. They're young and had not acquired much.
All right. Then moving to the issue of the custody of the minor children, clearly Mr. Mowell is facing an attempted first-degree murder case charge that is yet to be heard, and he's presumed to be innocent of those charges under the criminal law. But in this court, the court finds that the proof is established for, at the lower burden of, by preponderance of the evidence, that he did in fact attempt to take the life of his wife. And for that reason, the court finds that she should be granted sole and exclusive custody of the minor children. She will be designated their primary residential parent. I do not set any sort of visitation for Mr. Mowell whatsoever at this point. If Mr. Mowell in the future is released from custody and in the future chooses to try to have a relationship with his children, he will have to file something with the court to establish some sort of visitation. And for that reason, I'm not delineating any type of holiday or any other visitation. The children will be with Mrs. Mowell exclusively. While I can only extend an order of protection for 1 year and then renew it year to year, I can issue a permanent injunction, and this court will issue a permanent injunction against Mr. Mowell, who is, I'm sure, under bond conditions anyway under his criminal case. But that permanent injunction prohibits and bars him from any contact, directly or indirectly, with Mrs. Mowell or with the minor children. Again, that would defer to any future order regarding any sort of contact that a chancery court or domestic relations court allows contact with the children upon his release from custody. But at the present time, he is not to be allowed to have any type of custody. The proof in the case is, as I understand it from the file at least, that the children were present during his assault on Mrs. Mowell and tried to talk him out of doing the things he was doing. That's set forth in the complaint itself. And because it was a sworn pleading, I will take that as, and take notice of that. So based upon those facts, I don't think it's appropriate for him to have any contact with the minor children at the present time. Again, if he's released at some time from in the future or found not guilty for some reason, then he has the right to come back into court and to seek some sort of visitation with the minor children. The issue of child support is simply reserved. He obviously at the present time is incarcerated, has no ability to pay any sort of child support, and the court finds that a name change is in the best interest of the minor children as was requested. Based upon all of those factors, those are my ruling. Anything that I failed to address?
Judge, that is everything.
All right.
I did not bring a final decree over, not knowing how this would be handled
You'll
today.
prepare the final decree and submit it along with your affidavit of attorney's fees.
I will. Thank you, Judge.
All right.
What makes this case so powerful isn't theatrics, it's precision. This courtroom shows exactly how civil law responds when violence destroys a marriage beyond repair. While many viewers instinctively focused on the criminal charges still pending against Mr. Still, today's hearing operates under a completely different legal standard. In criminal court, guilt must be proven beyond a reasonable doubt, but in civil court, the judge only needs to determine what is more likely than not. That lower burden, called a preponderance of the evidence, was overwhelmingly met here. The testimony established a devastating chain of events: 9 stab wounds, an intentional fire, catastrophic injuries, and children present during the attack who attempted to intervene. Those facts alone shaped nearly every ruling that followed. Importantly, the judge made something very clear on the record: marital property division is not supposed to be punitive. Fault alone does not usually determine who gets what. But when one spouse's actions directly destroy the marital estate, eliminate insurance coverage through intentional acts like arson, and saddle the other spouse with massive medical debt, the consequences cannot be ignored. That's why the court awarded the wife the home, despite its damaged condition and mortgage, along with both vehicles and any potential equity, not as punishment, but as equitable relief. The judge specifically cited the denial of homeowners insurance caused by intentional arson, the medical expenses incurred, and the financial reality that this family now faces because of the husband's conduct. Even the GoFundMe funds were addressed carefully, classified as separate property because they were raised specifically for her recovery after the attack. But the most consequential rulings had nothing to do with money, they involved the children. Based on sworn testimony and uncontested evidence, the court granted sole and exclusive custody to the mother, denied all visitation, and issued a permanent injunction barring the father from any contact, direct or indirect. That decision wasn't emotional, it was methodical. The judge relied on the fact that the children were present during the assault and that exposure to that level of violence poses long-term psychological harm. The court even approved changing the children's last names, recognizing that in a small community, association with a highly publicized violent crime can follow children for life. That's a ruling courts do not make lightly. It reflects a finding that protecting the children's future identity outweighed preserving paternal naming rights. It's also critical to understand what the court did not do. He repeatedly emphasized the presumption of innocence in the criminal case. Civil courts exist not to punish, but to stabilize, to allocate resources, protect children, and prevent further harm. In that role, this court acted decisively. This hearing is a sobering reminder that justice doesn't always arrive with raised voices or dramatic confrontations. Sometimes it arrives quietly, through careful findings, permanent injunctions, and orders designed to protect the most vulnerable people in the room. Now we want to hear from you. Do you believe the judge struck the right balance between fairness and protection? Should civil courts have even broader authority when extreme domestic violence is proven? And where should the line be drawn between parental rights and child safety? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.